Decision G1 Pad 24. Introduction. Enlarged Board of Appeal of the European Patent Office. Decision G1 Pad 24. Issued on 18th June 2025. This decision concerns the interpretation of patent claims and the role of the description and drawings in European patent law. Background of the case. The referral arose from Case T 439 of 20-22. The core issue: when assessing patentability under the European Patent Convention, should the claims be read in isolation, or must the description and figures always be consulted? Previously, EPO practice allowed examiners to rely on the description only when the claim text was ambiguous, but national courts and the Unified Patent Court often used the description and figures as a regular part of interpretation. This misalignment created legal uncertainty, especially in high-tech fields like computing, quantum mechanics, and biotechnology. Principle 1. Claims as the basis. The board confirmed, the claims are the foundation of the patent. They define the boundaries of the legal monopoly. Articles 52 through 57 of the European Patent Convention make it clear: patentability is assessed by examining what is claimed. So, the wording of the claim is always the starting point. Principle 2. Role of the description and drawings. But, and this is the crucial shift, the description and the drawings are not optional extras. They must always be consulted when interpreting claims, not only when a term is ambiguous, not only when uncertainty arises. Why? Because Article 69 of the EPC and its Protocol on Interpretation require that the scope of protection must be determined by both the claims and the description together. Thus, an examiner, a judge, or a litigator cannot simply stop at the plain wording of a claim. They must see how the inventor described the invention, how the figures illustrate it, and how the technical problem is solved. Technical illustrations. Consider a quantum computing invention. The claim may state, a quantum processor comprising qubits. Clear enough. But the description may reveal that those qubits are manipulated by microwave pulses, and that the invention solves the technical problem of error reduction. Or think of an algorithm. A change in the algorithm of a computer program may, at first glance, look abstract. But if the description shows that the change improves how data is processed in a mobile network, the claim acquires a technical character. This alignment between claim and description ensures that the invention is not misunderstood as a mere mathematical method. Outcome on simulations. The board also touched on simulations. If a simulation aims to generate scientific or technical knowledge about a field outside the computer, for example biomechanics or material testing, then it contributes to the technical character of the invention, regardless of the simulation's outcome. The act of simulating, when tied to a technical purpose, carries technical weight. Definition of technical in GMNA 124. Decision G 124 also clarified what counts as technical. A feature is technical if it involves 1. A physical embodiment of the invention, even partial, or 2. Abstract information or concepts which, in the invention's context, are clearly identified as part of solving a technical problem. This means technology is not limited to hardware. Software features, simulations, and even abstract models can be technical, provided they serve a concrete technical purpose. Comparative legal view. The Enlarged Board also looked at German case law. In Germany, technically qualified judges had already established a broad and consistent understanding of what technology means. The conclusion was, Parliament cannot replace a technical qualification assessment with formal education alone. The German approach reinforced the need for a common, harmonized definition of technicality across Europe. BAM. The underlying appeal. The power converter. The concrete case behind this referral involved a power converter, designed to output a current for charging a battery. A simple but highly practical invention. Here too, the question was, should the claim be read strictly, or should the description guide how the converter's technical contribution is assessed? The board answered, the description must always be part of the interpretive process. Final order of the decision. To summarize, the Enlarged Board ordered 1. The claims remain the basis for assessing patentability. 2. The description and drawings must always be used to interpret the claims, not only when ambiguity is suspected. 3. This interpretation aligns EPO practice with national courts and the Unified Patent Court, ensuring legal certainty across Europe. Closing. In conclusion, Decision G124 strengthens the role of the description and drawings in patent law. It brings harmony between the EPO and the courts of Europe. It also expands the recognition of technical aspects, covering not just physical inventions, but also algorithms, simulations, and emerging fields like quantum computing. Decision G124, a milestone in European patent law.